Welcome to the Supreme Court Podcast.
All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
Imagine you have a lot of followers online and you decided to post a rant against a judge, including stuff that may not necessarily be true. Your post was shared by many of your followers, making it go viral. Can the court cite you in contempt? Hi, I'm Attorney Mike Navalio, Supreme Court Chief Communications Officer. It's the 22nd of August 2024, and today we talk about the case of Lorraine Badoy, decided on August 15, 2023. It's a decision by the Supreme Court en banc, penned by Senior Associate Justice Marvic MVF Leonin. With me is Attorney Camille Lau, Court Attorney from the Office of Senior Associate Justice Leonin. Hi, Attorney Cam. Thanks for joining us today.
Hi, everyone. Thank you for having me, Attorney Mike.
All right. So we know who Lorraine Badoy is. She was a former government official with the National Task Force to End Local Communist Armed Conflict, or NTF-ELCAC. But how did she get to face an indirect contempt case before the Supreme Court?
So, Badoy was actually reacting to a resolution issued on September 21, 2022 by Judge Marlo Magdoza Malagar, which dismissed the petition filed by the Department of Justice to prescribe the Communist Party of the Philippines, New People's Army, as a terrorist group under the Human Security Act. When we say prescribe, it means to have the CPP-NPA judicially declared a terrorist organization. 2 days after, Badoy uploaded a public post on her Facebook page where she launched multiple insults against the judge. Badoy claimed that the judge was friends with the CPP-NPA National Democratic Front and that the judge weaponized a court of law to further inflict harm on the people that have long suffered the excesses and inhumanities of the CPP-NPA-NDF.
Did she cite any evidence to support her claim that the judge was friends with the CPP-NPA-NDF?
No, she did not. Worse, Badoy also threatened to kill Judge Magdoza Malagar. She said, "So if I kill this judge, and I do so out of my political belief that all allies of the CPP-NPA-NDF must be killed, because there is no difference in my mind between a member of the CPP-NPA-NDF and their friends, then please be lenient with me." And she didn't stop there. In a second post on the same day, Badoy even threatened to bomb the offices of judges whom she deemed as friends of terrorists. The next day, Badoy uploaded another post describing Judge Magdoza Malagar as unprincipled and rotten, and claimed that the judge's husband was a member of the CPP.
Attorney Cam, do we know what was the impact of the Facebook post of Badoy?
So let me point out that Badoy has over 166,000 followers on Facebook at that time. So her post generated comments, remarks, images, and videos with the same vitriol as her post. Some even openly supported her statement and offered assistance. They even asked for Judge Magdoza Malagar's address. Badoy would later compile these responses and upload them in another post.
But wasn't there any form of pushback against Badoy's post?
There were also groups of judges like HUCOM and Philippine Judges Association and the Integrated Bar of the Philippines who issued statements denouncing Badoy's posts. So her remarks even caused the Supreme Court to issue a show cause order against her, and a group of lawyers even filed a petition before the court to cite her for indirect contempt.
Attorney Cam, when you say cite for indirect contempt, what does that mean?
To be cited for contempt is essentially to be punished for misconduct that adversely affects how courts administer justice. This power is essential to preserve order in judicial proceedings and ensure the due administration of justice.
You mentioned indirect contempt earlier. How is this different from direct contempt?
Direct contempt is committed when one engages in misbehavior inside or near a court that it interrupts the proceedings. Indirect contempt, on the other hand, targets actions that are committed outside the court, including improper acts that tend to impede the administration of justice.
So in this case, the misconduct in question are the post made by Badoy against Judge Magdoza Malagar. Did the Supreme Court find her post punishable by contempt?
Yes, the court found that her posts constitute indirect contempt. Badoy's assertion that Judge Magdoza Malagar dismissed the DOJ's petition because of the judge's supposed friendly ties with the CPP, NPA, NDF threatens the impartial image of the judiciary. Similarly, her claim that the judge lawyered for one of the parties due to her alleged political leanings harms the court's administration of justice. She even put into question the legality of the decision by stating that the CPP, NPA, NDF had a hand in drafting the decision.
Right, but Badoy argued that she is merely exercising her right to free speech. Isn't she correct in saying, I'm just criticizing the court?
The right to free speech is a constitutionally protected right. However, this right is not absolute. It must be balanced with other equally important public interests, including the protection of judicial independence. The court actually said, one's right to freedom of expression must be as fully protected as possible. However, its exercise must never transgress the equally important aspects of democracy, not least of all, the judiciary's dignity and authority. So while the freedoms of expression, speech, and the press include the right to criticize judicial conduct, such exercise must not threaten judicial independence.
So the public is not prohibited from criticizing the court, but where do you draw the line?
The public can remark on the court's rulings, but there is an important line between legitimate criticism and illegitimate attacks upon the courts or their judges. Legitimate criticism is welcome, but illegitimate attacks against a court or a judge not only risk the inhibition of all judges as they discharge their constitutional responsibilities, they also undermine the people's confidence in the courts.
So legitimate criticism is not subject to contempt, but how do we know when criticism is protected speech?
Speech may be considered protected, meaning this will not subject the speaker to contempt if it meets any of the following. 1. It is made in good faith and without malice. 2. It is a fair and true reporting of a proceeding or any of its incidents. Or 3. It is a fair commentary on matters of public interest. So to be considered fair, the comment or criticism must be grounded in truth and facts.
In Badoy's case, can she claim that she made it out of an honest-to-goodness concern for the courts?
According to the court, Badoy's criticisms were not made in good faith or without malice. Her undeniable use of violent and abrasive language when she hurled accusations at Judge Magdoza Malagar proved that she did not act with an honest sense of duty or with an interest in the pure and efficient administration of justice and public affairs. Instead, she was impelled by a self-seeking motive. Mere criticism or comment on a decision of the court made in good faith may be tolerated. However, the court found that Badoy's criticisms were not made in good faith or without malice. Her undeniable use of violent and abrasive language proved that she did not act with an honest sense of duty or with an interest in the pure and efficient administration of justice and public affairs.
What about truth as a defense?
Badoy's comments were not a fair and true reporting of a proceeding, as she failed to provide any evidence as support. She made explosive statements that were not grounded in truth and facts, and thus do not constitute fair commentaries on matters of public interest.
Attorney Cam, what about Badoy's defense that she didn't really threaten to kill the judge? It was just a hypothetical syllogism prefaced by the words, "So if I kill this judge," how did the court consider this statement?
The court didn't buy that excuse. If it was mere hypothetical syllogism, she should have made that clear to her followers. Instead, her explosive statements threatening to kill Judge Magdoza Malagar and other judges were clearly made to incite her followers and produce imminent lawless action, as evidenced by the multiple comments subsequently posted openly supporting the statements and even offering assistance. Some even went as far as asking for Judge Magdoza Malagar's address, a clear sign that they intended to execute Badoy's call.
Right. Why was the court so concerned, though, over Badoy's statements on social media? Is there a concern that those statements could actually happen in real life?
As shown by past experiences here and abroad, when such incitement to cause lawless violence is done through social media by its influencers, the imminence is high that it will actually be committed by those provoked. Badoy's statements have the power to spark a deluge of assaults against the judiciary and its members, and so the court just couldn't let it slide.
So what can online personalities and influencers learn from this case, Attorney Cam?
The court said, in today's digital age, where credibility seems to be measured by online popularity instead of experience and hard-won credentials, online personalities or influencers must be put to task for the effects of their speech, since unregulated speech online and the unabated spread of fake news pose very real consequences, even in the real world. The court also warned online personalities that they have a duty to verify the truthfulness of the content they put out on the internet. They must validate the source of news through fact-checking and even through source-checking, so they won't unwittingly disseminate fake news and even cause real-world harm.
All right, good discussion, Attorney Cam. Thank you for joining us today.
Thank you as well, Mike.
And if you wish to read the full text of the court's decision, you can go to the Supreme Court website and e-library. Just search for Re Statements Made by Lorraine Badoy, AM number 22-09-16-SC. And here's Supreme Court Information Officer Tiff Atendido Beltran for this week's Roundup.
Thanks, Attorney Mike. At the Supreme Court this week, the Supreme Court ordered the Commission on Elections to halt the scheduled plebiscites on September 7 and 21, 2024 to ratify the creation of new municipalities in the Bangsamoro region. The court nullified Section 5 in Bangsamoro Autonomy Act numbers 53, 54, and 55, which limits the plebiscite for the ratification of the new towns only to voters in the new municipalities. The court said voters of the mother town should also be consulted in accordance with the Constitution. The court required Ombudsman Samuel Martires and Department of the Interior and Local Government Secretary Benjamin Abelos Jr. to file their comment to the petition filed by Cebu City Mayor Michael L. Rama. Rama is seeking to reverse the Ombudsman order placing him under preventive suspension for allegedly constructively dismissing employees at the Cebu City Assessor's Office. His petition also challenges Section 24 of the Ombudsman Act of 1989 and Section O, Rule 3 of the Rules of Procedure of the Office of the Ombudsman, in as far as they apply to elective local officials like Mayor Rama. The court gave respondents 10 days to file their comment to the petition. The court found Attorney Nilo Divina guilty of simple misconduct under the Code of Professional Responsibility and Accountability, or CPRA, for committing impropriety when he sponsored the trips of Integrated Bar of the Philippines Central Luzon officers. Attorney Divina was fined 100,000 pesos. The court also lifted its suspension of the IBP Central Luzon officers' election and ordered the election for IBP Central Luzon governor for the 2023 to 2025 term to proceed. The court approved the guidelines to facilitate the transition to electronic filing as the primary mode of filing pleadings before first and second level courts. Starting September 1, 2024, no trial court shall act upon any pleading unless it is accompanied by an electronic transmittal through email. The full text of the guidelines shall be uploaded to the Supreme Court website once available. The court announced that the next Sharia bar examinations will be held in May or June 2025. In a statement, Associate Justice and 2025 Sharia Bar Exams Chairperson Antonio Tico Jr. said that in line with the Strategic Plan for Judicial Innovations 2022 to 2027, or the SPJI, the Sharia Bar exams will continue to be digitalized and held in local testing centers throughout the country. Interested participants for the first leg of the proposed amendments to the Rules of Civil Procedure regional consultations on September 4, 2024 in Cagayan de Oro City may now register by visiting the CivPro Regional Consultations microsite on the Supreme Court website. The CivPro Regional Consultations aim to engage various stakeholders including judges, legal practitioners, and the academe in discussing proposed amendments to the Rules of Civil Procedure. Registration for the first leg of the regional consultations is until August 30, 2024. And that's your Supreme Court this week. I am Tiffet Indido Beltran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navalio, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, and YouTube. You can also catch previous editions on our website. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Jen Tuazon Irania as writer, Don Ryan Balza, Victor Laranio, Brian Austria, and EJ Mijares as sound editors, and Tyke Flores as web editor.